Continuation meeting is being, oh, can you make, oh, good. And you don't, wonderful. Terrific. Thank you, Ted, very much. I'm sure most of you know Ted Chagrin, he's just been wonderful. This whole thing. And Louise, of course, has just been out of this world and making this whole thing. So I'm very grateful to both of them. So I'm not sure quite where I am now. Let me try. Oops. No, because it's got this. So I'm going to take a wild stand here. I can't make got it go away.
Oh, I see.
I'm so sorry. Tech is wonderful, but oh, wait a minute. What if I do that? No, it's not working either, Ted. I'm so sorry.
No,
If it doesn't go away soon, I'll just say, where's it? There it is.
the cursor moves back and forth between the big screen
Oh,
and the
yeah.
little screen.
No. Okay.
And let's make sure you're good. Now we got still one more thing. There you go.
Okay. What?
Did we?
Here it is.
Oh, it did that thing again. I know. I can fix that.
I'm so sorry. Tech is wonderful, but
There we go.
tendency to overload.
Oh, hold on. There. Yeah, hold on. One
Just
thing.
on that.
This is been doing that. Okay.
Yes, it is.
Yeah, terrific. So now we're doing examples of the new understand by this different perspective from the point of continuation or resolution. All right, first, resolution is imposed, not consensual. Resolution is a bargain imposed by law, which is quite different from liquidation, in which results are fixed by law for everyone. Often it is in academic articles or judicial decisions in the US, a Chapter 11 case is treated as if it were a traditional consensual workout, failing to reflect the fact that the reasons the business filed.
I understand what we've got here is potential, it's been identified as a potentially assumable and assignable contract at this point.
It's probably a much better talk than mine.
There's,
This one.
there's a Salesforce contract, which
Was
is ordered, that was actually just compiling the correct application of
potential
Salesforce contract.
that is to remain in
And
this
then there, I
materially
know a
alter
Tableau contract, which has been
the
rejected.
legal rights of many creditors.
I don't have any evidence of a Slack contract, so I asked my client just to look and see, or what you
These
identified as
parties are often dismissed as holdouts.
contract. I don't
Extract
find
more
those on my
themselves.
considering.
Although they
as
may be
the contract,
dropouts.
And it may be that you're just
not
identifying
those.
those.
I'll talk to you about
differently.
that.
I
We
think
may
the
find, for
Slack
example, that a
contract,
failure
if
to
it
vote
existed,
rests on a
may have
belief that
expired by its
stakeholders are not
terms, and I
offering
don't
a
have that
realistic
information.
alternative.
So-
If not, we'll liquidate the whole place. We have with the matches are lit, burn down the business, which may not be. true.
The number I'm coming up with right now, that I just asked my client to confirm, is roughly 25,000. Your number.
And secondly, a sense that their vote doesn't matter, that the deal is a fait accompli. Sarah Patterson and others have pointed out that, by contrast, the absence of a moratorium makes schemes dependent on a certain level of consensus. And that's quite right. It's very different from Chapter 11. And when people talk about introducing the moratorium into schemes of arrangement, this is a point that I think you should keep very much in mind. That's a fundamental change that makes it more like Chapter 11, by introducing a substantially more coercive element than it would have without the moratorium. And of course, again, the perfect illustration is mass torts. We have all these plaintiffs all over America whose lawsuits are frozen for years because the company that is allegedly liable for their injuries has filed for Chapter 11. And their case is just frozen. Jonathan Lipsis and others have argued that these plans are too often adopted in the US with a fairly low percentage of eligible creditors voting. I've got an empirical project that I'm just getting underway to look at that point. It's really amazing. We looked hard at a sample of cases we collected from 2014 and 2018 in Delaware and New York. You can't get more high-class districts and West Hughes districts for Chapter 11 in Delaware and New York. You can't find anything about what the votes were. That can't be true, Jay. Come on. Yeah. We can't figure it out. My poor RA has been going crazy trying to find it. It's not there. So we're going to pursue that, needless to say. All right. And this defect, I think, is true in some international cases as well. That's probably going to be even harder to figure out empirically. In light of this coercive aspect of resolution, various countries, and this is a big point, I think, for all of us to think about, various countries in adopting some form of resolution have sought to provide a disinterested watchdog while leaving management in control, such as the monitor under the Canadian law or the conciliator in Mexico. Other jurisdictions, including mine and the UK, have largely left the monitoring job to the judges under standards more appropriate for a traditional agreed workout than a judicial order, imposing a bargain only some shareholders have reached. That's probably more fun, actually. All right, next. Control is the most important priority in resolution. I told you about the IOTA and Elias thing. Of course, Elias is now in Harvard, so that means he's right about more or less everything. And the two of them, and IOTA is very good. He's a perfect. And they've written this terrific article about the sale of the Chapter 11 process, and it really illustrates this point that I want to make to you. Control is the way that you is the thing you most care about in Chapter 11, more than your security position, more than anything else is control. And the reason is right there: lack of fixed results, right? The flexibility that Chapter 11 offers for rescuing a company is exactly the flexibility that can be exploited by those in control to get results that are very congenial, shall we say, to themselves. Second, we continue to focus upon the priority rules while the key is control. That view would change leverage up. Ted Janger and Melissa Jacoby have written a couple of terrific articles, one of them in Yale, about reanalyzing the position of secured creditors, for example, in Chapter 11 proceedings. Are they really entitled to say, oh, well, these assets are all ours, so it's whatever we say is it? And Ted and Melissa have said, well, actually, no. What you're entitled to under American state law, the Uniform Commercial Code, is the liquidation value of the assets. That's all you're entitled to. And we know from the work of Ronald Mann and others that liquidation value is warm spit. It's awful. Nobody wants liquidation value, no matter how strong your security interest may be legally, because you just don't get anything for it. That's the sort of rethinking that we have to have. Slide. Oh, yes. All right. Let's see. A widely recognized example of the way in which continuation is radically different is the matter of financing. I won't go into detail. This essentially is two types. One is plan financing, that is to say, the financing you need to survive after the first day, so-called first day orders in the United States. So plan financing to keep the company going. I mean, the reason filed for Chapter 11 is that very often it was cash short and couldn't get more credit. So plan financing, and then the second is exit financing. So you have to have a way to have a financing set up, and you can say to everyone concerned, now we can survive here going into the future because we have this strong financing in place and approved by the court. I mean, there's no better loan agreement than one that's been blessed by a bankruptcy judge. It is more or less bulletproof. And so it's possible to attract good financing. All right, the next one. All obligations, monetary and otherwise, have to be covered. Okay, there we go. In addition to finance, aren't you kind? Thank you, Louise, very much. A more widely recognized example of the way in which continuation is radically different. Oh, is finance, we covered that. In addition to finance, other effects mean that resolution must be a tool designed to structure the future of the company toward resolving all of its obligations, commercial or fiscal, to employees or tort victims, to environmental and financial regulators, among many others who might not be called creditors in a traditional reorganization. One of my favorite examples of this is the Exide case. These were the people who put the lead in your paint and your gasoline. And so Exide filed for Chapter 11, came out of it. But the EPA came in, the Environmental Protection Agency came in and said, you haven't provided both for the cleanup of the old messes that you made with poisonous substances of various kinds, but you haven't provided for new messes we're going to discover down the road. And until you do, your plan should be unconfirmable. And the court agreed. And they had to proceed then to try to find ways to estimate, get experts and so estimate what their exposures might be and what they would have to do to deal with those exposures. If you want to go to bankers or hedge funds or anybody else with your plan and get your exit financing, you really need to be able to say, oh, yes, all that is taken care of. And in any event, society needs to know that. Society needs to know that this is not an escape from obligations that we take very seriously, like environmental obligations. See, next one. Number 5, resolution requires a new look at what we call avoiding powers. The old avoiding powers will focus on asset transfers almost entirely. They're still important, don't get me wrong, but they are not what we really are concerned about in a resolution proceeding. The focus in resolution is negotiation and making new bargains in a new post-distress balance of power among the players. Given that, to what extent should the court's power to set aside transactions be focused on the transparency of pre-filing negotiations and agreements, new powers to avoid or modify pre-filing agreements concerning resolution plans, or perhaps recent secured borrowings that are not necessarily avoidable as fraudulent conveyances or even preferences. There may be for new money, but it's the resolution. In the resolution context, we can approve all of this without any regard to anybody else who's involved in the case, and then file our petition in court. So it's all set in concrete before we proceed. Should that sort of transaction be permitted? If it was in the contemplation of insolvency, that is to say, resolution, I think those are sorts of questions we're at least going to have to think about in a serious way. I think transparency is also going to be absolutely critical to the continuation, to the development of continuation code. And if you look to the scholarship of people like Lynn Lepucki, Jonathan Lipson, and Ted Jangen, and Lindsay Simon, among a number of other excellent scholars, but those are some of the leading ones, you'll see all of this documented and discussed in detail. Because of them, I get to skip doing that part. So, slide 15, effect on the law of corporate groups. Liquidation and the corporate law of limited liability entities have always and necessarily been closely linked. I was so pleased, Lord Hoffman, when you made that very point, because of all of your experience in the commercial field. So, and that's exactly true, and one that all of us should be thinking about. A liquidation model for a corporation assumes that shareholders will never, this is just one example, will never get value for a corporation. In resolution, some value might remain for them if the going concern value is sufficiently great. For example, in a startup company, they just can't get financing at the tail end. That important change relates not merely, however, to shareholder investors, but also to the parent corporation in a corporate group. This is where I'm really going to raise some hackles, so forgive me. In the context of corporate groups, the corporate liability shield meant to protect owners may be illegitimate in resolution insofar as it permits manipulation by a parent company, for example, Johnson & Johnson, in a corporate group, as illustrated in that case. Texas two-step controversy in the US, as you may have read about it, which consisted of assigning all the liabilities to a subsidiary and then putting that in bankruptcy. What a wonderful idea. When I was in school, you couldn't assign liabilities, only assets, but I must have missed that class. The traditional ideas
in Texas, right?
That's right, exactly so. The traditional ideas about the liability of a parent corporation may be obsolete in a world in which the corporate group will continue in business as before, probably under the same name, In this context, some veils may be banished from the corporate harem. Size, next slide, yes. Okay. The emergence of Chapter 11 cases dominated by tort liability is one of the especially vivid illustrations of the changes required by continuation. And as you probably know, we have these huge mass tort cases in the United States, creating very, very simple, serious economic and moral questions with which we are daily struggling. Part of the problem that all of you may not have been exposed to is that in the US, our class action sort of thing, very famous in the rest of the world, is outrageous thing that it is, our class action arrangements have been so narrowed by the Supreme Court that they're no longer adequate to deal with these mass tort cases. So in many cases, the company, the defendant, will file for bankruptcy just to organize all the litigation and hopefully to control it in its favor as against all these plaintiffs. Very, very interesting stuff. And we've got a long way to go to figure that out. That's especially a difficult problem, not only in mass torts cases, but in all these future-oriented cases. That is what we're going to do the next day, by deciding what to do about future obligations. What about the person who used the baby powder after the conclusion of the proceeding, not knowing perhaps that it was dangerous? So in up to 1978, a tort claim was literally unprovable in an American reorganization proceeding, indeed a liquidation proceeding either. It's unprovable. That changed in 1978 precisely because of continuation, precisely because you can't let this business go on and give it the sweeping discharge that we have decided on unless you've made some provision for its tort liabilities as well as others. And we don't have that many cases in which insurance is guaranteed to cover all of those obligations. I think most often, someone like Johnson & Johnson is a self-insurer. So the next thing is a problem that this problem is not created by continuation, but it's a major problem in our law. And that is, how do we get it right in terms of initiating bankruptcy proceedings? So we solved that. You'll remember my saying, we solved that by saying, well, the DIP will be in control. So it's okay. You can not worry about filing an insolvency proceeding. Managements are indeed willing to file at Chapter 11. Boy, are they, because it leaves them in control. Perhaps we should consider a modified version of a suggestion from Alan Swartz, who's at Yale. And Alan has quite seriously proposed bribing management to act reasonably and correctly on behalf of creditors. Well, maybe that would produce a better result than what we have now. So the next slide. The scope of resolution, the competing interests to be weighed, and the number of affected persons is much greater than in liquidation. More broadly, a continuation case in Chapter 11 is not at all like most civil cases. A large resolution case compares to ordinary civil litigation as a city compares to a single street. Because recent cases regularly present to the court the chain of nursing homes with elderly and injured occupants, the bus company that is central to the community's function, and the Art Institute, as in Detroit, that is the cultural heart of the city, and not just furniture and cans of gasoline at all. Another scholar, Melissa Jacoby, has written penetrating articles about these developments. Another scholar, Nathalie Martin, has discussed cases that present, and this is an interesting point, choices between jobs preservation and economic returns. For example, we have competing bids for a company, and one of them promises to keep more jobs. The other one promises more money for the creditors. How do we deal with that? Now, traditionally, that was easy. The creditors were the only ones that had a stake. I don't think that can be true in continuation. And I think if the community at large starts feeling that is the kind of trade-off being made, there will be a reaction in the United States. One other point I'll mention, much the same sort of competing considerations arise where the business may continue to harm the environment or sell possibly dangerous products, but serves important economic interests for the community. In competition law, for example, similar concerns inform the failing company doctrine, under which judges must balance the risks to competition against the benefits of a proposed merger. That seems to be the perfect case in which Chapter 11, all gathering all of it in one place to make those judgments. And if they're wrong, you can go up on appeal, but with the caveat that I mentioned before. Next slide, almost there. Employees are an instance of the general problem of ongoing obligations, but a very special one. In the US, traditional liquidation treats employees as mere creditors, addressing the wages they are owed, but not the value of their jobs. That goes back to the prior point. Other countries, notably Mexico, are more enlightened on this point, but every jurisdiction faces the conflict between future jobs and returns to commercial creditors. I should say that I had the rare benefit in the structure of the Moss-Fletcher lecture of presenting roughly the same lecture, a little bit different in emphasis, but roughly the same lecture in Mexico City a month ago, and getting a whole set of reactions from that civil law jurisdiction. And that has, by the way, on its face, on paper, a very advanced reorganization law that apparently no one follows. So it was a very interesting discussion arising from that. Okay. Finally, we have the international side. Some of you will say at last. I don't know if you can read the caption on this thing. Everybody see it? Yeah. One of my favorites. When we talk about international law. All of these points would be of interest to my good friends, Gabriel Moss and Ian Fletcher, whose wonderful work and scholarship covered the whole field of the financial distress of businesses. But both of them had a special interest in the international dimension. What is the impact of the continuation goal on that side of things? The idea of continuation under various names and various configurations has spread across most of the world, but continuation was not the dominant idea when we met in Vienna in 1995 to write the model law on cross-border insolvency, which is now chapter 15 in our law. And of course, you have it as well. Oh, yes, and actually I should give you a picture of Vienna and the buildings in which we met to negotiate all these things over 2 years. We were really tough in those days. It was 2 weeks at a time, first in Vienna, then in New York, and back to Vienna, 2 weeks of shot. But we came up with something I think fairly good. But continuation, I can say, someone who was there, I had the honor of being the head of the US delegation to this whole negotiation. All of us were much more focused on a liquidation model. That's what people understood all over the world. Indeed, a few of the people in attendance sort of, sneered at Chapter 11 and things like that, just some real bankruptcy and so forth. So thinking around the world has really changed pretty dramatically since that was the case. So 40 of us in a room in Vienna. I'll tell you one other story, if you'll forgive me. We got there on the first day and we're all there. We got our flags to put up when it was time to talk and all that sort of, I'm sorry, to intervene and all of that stuff. And so what happened? There was dead silence. Oh, well, for a minute or two, no. The dead silence, and I'm not kidding, went on for almost half an hour. No delegate was willing to say anything. Now, I personally, of course, this is the only one I can report on, but I personally didn't want the US to start the discussion. That seemed like a really bad idea politically and so forth. So I wouldn't say anything, nobody else would. So finally, the Secretary General, who was a remarkable man, wish I could say his name right at the moment, but I can't. Anyhow, turned to the reporters and said, shut down the recorders, shut down all of the machines. Nothing will be recorded for the rest of the day. And no one will cite, sort of Chatham House rules, no one will cite anything that you say today in the future in this conference. So let's talk about this stuff. And that was just it. It broke the ice. And we all went on to work on something that now has been adopted in almost 50 countries in a subject which we were told at the time was impossible. People could never agree on anything about bankruptcy. It's too complicated and so forth. So now, having said that, though, it was the discussions at Insolvency were focused on liquidation cases. There's no question about that. If you look at the record, you'll see that that was the case. Now, wonderful things have happened by adoption of the model law. I'm very proud of the little part that I played in that process. But having said that, it was modeled on liquidation, right? We liquidate and some arrangement was made, and we want other countries to recognize the effect on the title to property, you know, and all that sort of traditional stuff. And that just doesn't have anything to do with what's going on under Chapter 15, and I assume in the laws of other countries in continuation proceedings. So that fact says to me, we need to really evolve and develop and amend, in our case, Chapter 15 of the US Code. In the American Law Institute project, in which I had the good fortune to be the US reporter, we invented the terms universalism and modified universalism, and they're now in common use around the world. Forgive me if I say, often in common misuse around the world, but nonetheless, we had something to do with creating those terms. And of course, Ian Fletcher and Bob Vessels wrote the global version of those rules and caused them to spread all over Europe and a number of other countries as well, which is an invaluable contribution. So things are better than they were then, when you couldn't get a recognition of an insolvency proceeding in another country under almost any circumstance. It might be much beyond that, but they're still not right for a field of law of financial distress, that now prefers and most often pursues a continuation. I want to mention in particular, and this is the one where I'm getting more trouble, the model law's policy of centering global proceedings in the COMI, that is the center of main interest of the business, were not well crafted by what we did. We were focusing on liquidation, getting approval, getting recognition of those sorts of proceedings. Yet, a deal for a continuing business made among insiders, including insider creditors, approved in a jurisdiction with no economic stake in the outcome, you see where I'm going, will probably not take into account the interests of all stakeholders in resolution. For example, the relevant national policies in the affected countries, giving special protection to bondholders or to the effects of the deal on competition or on the environment. The distant haven jurisdictions will be too expensive and too exotic for many parties with legitimate interest in the outcome, including regulators. So I have some recommendations for amendments to the model law. Eliminate registration as a presumption of the location of COMI. Many in this room will not applaud that result, but I think it's essential. We have so many companies that are registered in, Delaware is the least of it, but nonetheless, there's one that have nothing to do with the business or the economic or social policies of the company. And even more, there's some wonderful sun-kissed islands that I love to visit, which nonetheless have nothing to do with the bankruptcy that primarily affects people in Ottawa. So I recommend that we get rid of that presumption. I should tell you, just as a matter of history, when we adopted that presumption, it was because our great concern in those antique days was swiftness. We wanted the automatic stay to come in effect all over the world right away. And the way to do that was to get recognition right away. And in order to do that, the simplest thing is to say, oh, well, if you file in the place where the company is registered, then we all have to recognize that's an okay place to file. Or at least there's a presumption that it's the okay place. That was the reason, no sense that this is the best way to do it or anything like that. And above all, no sense of what was going to happen when you then were going to reorganize some large company around the world doing business in 28 different countries on the strength of the local policies. So I think I got one more here. Yeah, the central tests for COMI, in my respectful opinion, are number one, should be the jurisdiction whose recognition of a plan would be most important to the success of the business going forward. Someone may come up with a better test, but I think that comes fairly close. Secondly, the capacity of the chosen court to control and protect assets and opportunities worldwide. There's no question China Fisher has been the classic example. Peruvian law just couldn't handle this worldwide conglomerate whose principal asset was indeed in Peru. And in that sense, how could one argue with that being the Comey? Except the courts didn't have the laws to work with there that would have enabled a worldwide reorganization. So they tried reorganization in Singapore and various places. Finally, ended up in New York. God help us. And frankly, everybody involved, the judge, the lawyers, did a brilliant job and managed to come up with a reorganization. It seemed brilliant to me. But the point is, sometimes we have to settle for a court that is not at the Comey. It's not ideal, but we'll have to do that. On the other hand, we ought to be giving serious deference, in my view, to choice of law rules that say the Comey should, the policies of the Comey must be taken into serious account. In that case, it would be the Peruvian employment policies, the Peruvian conservation policies with respect to fishing and so forth. You ought to take those very seriously. Okay, almost done. The central procedure, I think, in the conventional case should be real-time communication. Nowadays, and that real-time and complete disclosure of proceedings in a plan. Nowadays, most often, things come to the United States for recognition on a take it or leave it basis, either in a bankruptcy haven or in some other very distant country with very different laws from ours. Come to the United States, well, we want recognition and all these effects of discharge and so forth you can get in the US. We want those effects. And we want those results with nobody in the US, at least no judges in the US having been involved in any way, shape, or form, no monitor, no nothing. Well, that's a really bad result as far as I'm concerned. We did have in mind, even in those distant days in Vienna and New York, that people would be on the phone with each other saying, well, now we've got this huge case that's been filed and it obviously indicates a lot of assets in New York and therefore, and we want to talk to each other and understand what the red lines are in terms of public policies to be applied in resolving this company's difficulties. And so we also want to say that there should be complete disclosure to the recognizing court of how the proceedings was handled, what was disclosed to everyone, what wasn't disclosed, and so forth and so on. All of you, again, will come up with good answers to these questions, but I at least want to put them on the table today. You have been a most patient audience to listen to all of this. I am deeply appreciative of that. You'll be relieved to know I will not try to discuss more examples of needed new concepts and reforms. I've identified some elements. And most of these things, by the way, that I've talked about have already been recognized in the US literature, just it's been sort of one thing at a time. But we need to find a more coherent approach, and I wanted to provide a little bit of that. I hope this lecture and my future work to provide more conceptual coherence to promote its development. Better still, I will have done something useful if I have provoked you to think about other new approaches to financial distress. I look forward to discussing them with you. Many, many thanks to all of you. Oh, sorry.
Well, Professor Westbrook, we're extremely grateful for that wide-ranging lecture which you favored us with. I'm now going to invite Lord Richards to make some comments, and thereafter the topic will be open for discussion by anyone who wants to make a statement or ask a question. I'm told that there's been a recording of the lecture, as you would have seen, but so far as the discussion is concerned, they will remain as close and confidential as the proceedings in Vienna to which Professor Westbrook referred. And Louise will tell us how long we can go on.
Depends how much drink, how long you want your drinks, really.
All right.
Off we go.
Let me first ask Lord Richards to come and say what he said.
Well, Jay, thank you very much for a real tour de force of a lecture, as I'm sure everyone here will agree. Jay was speaking from an extraordinary lifetime of experience of both US and worldwide insolvency, if I may use that word, law. And as he said, he has lived through decades of change, both in the United States and generally, so far as the rest of the world is concerned, over a shorter period as we have sought to catch up. Jay has raised so many points in the lecture he's just given that it would be quite impossible for me, even if I had hours, which I don't, I just have 2 or 3 minutes to raise them all. But I just will pick out a few, if I may, with 1 or 2 comments on some of the UK points that he's raised. First of all, I thought particularly interesting was Jay's reference to the experience in the Great Depression in the 1930s and the attempts which the bankruptcy judges made then to save the businesses of mom and pop as being the basis from which Chapter 11 subsequently grew. In this country, for a very long time, really until 1986, liquidation was the only formal insolvency procedure available for a company. And oddly, I think it acted as a rather painful incentive to companies and their creditors and directors and shareholders to come up with something else. And so it acted as that spur, and there were a lot, I think, of consensual reorganizations achieved simply because the alternative for what is potentially a successful business was too difficult. I just thought of some examples from the financial services sector going back many years. I started in practice at the time of the secondary banking crisis in 1974-75. And looking back then, there weren't many of those secondary banks that actually went into liquidation. They were somehow or other swallowed up by other banks. Normally, in those days, it was possible for the governor of the Bank of England to call in the bankers and tell them that they jolly well had to save the banks, which is, of course, what J. Pierpont Morgan did in 1907 in New York City, when he summoned, and as I understand it, actually locked in a room in his mansion all the leading Wall Street bankers and told them they had to come up with a solution. It was also done in this country in 1890 when Barings collapsed. As a result, as Jay no doubt knows, but of almost topical interest, as a result of an overexposure to Argentinian government bonds. Some things never change. It wasn't possible for Barings when it happened again in 1995, nor was it possible for Lehman's in 2008. And it appears the reasons there was that it was impossible to gauge the exposure to those banks' liabilities because of derivatives trading. Their open positions were simply impossible. No one was prepared to take over the liabilities, which raises a point, I think, which has always interested me about Chapter 11, as to whether it's really about saving a business or saving the entity. Because although it's really the business that's important, not the entity, the impression I have got of the way that Chapter 11 operates is actually focused on saving the entity, and thereby, no doubt, saving the underlying business. But it arguably, I just don't know, and it's an interesting point as to whether that to some extent does favor the insiders in coming up with a solution which where there might not be quite, they may not be quite so favored if it was actually the business that was being marketed and was available for all comers. I mean, I don't know. It's just a thought. Though I think that one of the points that Jay made may point towards saving the entity as the correct approach, because it's only in that way that you will come up with a solution to the larger problems, environmental damage problems, mass tort claims, and so on, which, as Jay rightly says, society is concerned to see solved. So there are, I think, competing points. I think the Great Depression was one of those external events which causes huge damage to all manner of businesses, which is in no sense the fault of those businesses. I suspect now the matter would be dealt with differently. I'm not sure that any insolvency system, whatever one is really equal to the task of coping with that scale of problem. I think recent experience tends to suggest that. So the financial crisis of 2008 was largely dealt with by massive government support and by monetary policy on the part of the central banks. Lehman's did collapse. Bear Stearns had been saved earlier in the year. There was a desperate attempt to save Lehman's. Fortunately, Barclays Bank here was in the end forbidden by the UK Treasury from buying Lehman's, which was a great salvation for the UK taxpayer, I think. But I vividly remember a keynote address being given at a III conference in New York 4 or 5 years after 2008 by the man who had been the deputy chair of the Federal Reserve at the time. And he gave this extraordinary account of what happened over that weekend. Everyone here will remember, I'm sure it's engraved on our hearts, that Lehman's went into banking administration here and into Chapter 11 in New York on the 15th of September 2008. The decision made by the Chancellor of the Exchequer here was made on the Saturday, I think. So there was Lehman's to be saved? The White House said no. So Lehman's filed for bankruptcy the following day. Then bad news hit. AIB was fatally injured. And as the deputy chair of the Federal Reserve said, suddenly the banking crisis had moved from Wall Street to Main Street, and AIB was saved. And that required government intervention. The COVID crisis is another example. So far as the UK is concerned, it was a massive furlough scheme for employees, together with statutory moratoria on, for example, possession proceedings by landlords and mortgagees, and on creditors' applications to wind up companies. So that's not to say, though, it's not to detract at all from the investigation as to what is the right way of dealing with financially distressed companies. But there are some circumstances where it will be really beyond, I think, the scope of any system to cope. If I may, I'll just pick up a few other points that Jay made. He referred, I have the advantage of a script here. He referred to the difficulty that judges face in fulfilling their duties under Chapter 11. And I think that's an interesting point for any of us who are judges who are here today, as well as for others. I was interested by what Jay said, that the US trustee seems tentatively to be possibly taking more interest. And I think that's an interesting point to make. I thought also in the same vein, it's very interesting to note Jay saying that we should have anticipated that there would be too many cases where due process and the rights of non-insiders were sacrificed to the success of obtaining a deal. And there was literature which is suggesting that may well be the case. And if so, how does one deal with that? And that's it seems to me a major point. A point made also, which was of particular interest, was the to me was the relationship between company law and insolvency law. That's of some topical interest in this country because of a recent decision of the Supreme Court in the Sequana case, which examined what duties directors owed under English law in circumstances where their company was approaching insolvency. That was a case, as some of you at least will know, which actually arose out of massive US environmental claims, cleanup costs for the lower Fox River in Wisconsin as a result of pollution by a paper coating business. The other aspect of that, which Jay mentioned, is the possibility of the corporate veil becoming a little more see-through. That is very much against the trend of the authorities in this country, where I think it's fair to say that in 2 recent cases, the Supreme Court has really said you almost never, possibly never, can lift the corporate veil. So we'll have to see how that develops. Sorry. The point mass tort claims. Mass tort claims have now arrived here with a vengeance. Just to give 2 recent examples, the Supreme Court in the last few weeks gave judgment in a case called Jala, which concerned nuisance claims brought against oil companies in respect of pollution in Nigeria. They held actually that it was not a continuing nuisance, and therefore I think that the claims were time barred under the limitation. But it's an example of a mass claim. Even more recently, well, it's not Supreme Court, but the Court of Appeal has decided procedural and limitation issues in a claim brought against the BHP group arising out of the Fundão Dam catastrophe in Brazil. At the time that it was before the Court of Appeal, there were about 220,000 individual claims filed. According to a newspaper report I read more recently, that number is now 400,000 individual claims. Now, there's no suggestion that the defendants in any of those cases are in need of the services of any insolvency law, but of course it did happen with Turner and Newell and other asbestos companies, and that produced substantial problems. But there were resolutions to those problems, I'm pleased to say. I won't comment at all, I think, on what Jay has said about Comey, but that I suspect is something that people here may have views about. The only other 2 points I would just ask, whether it's for any thoughts, is whether insolvency law does form some purpose as a form of economic Darwinianism, whereby bad management or obsolete businesses can be discarded. And finally, to what extent is our Chapter 11 and other proceedings affected by the trading in debt of companies in insolvency proceedings? I had the slightly startling experience when I was sitting as the judge dealing with cases in the Chancery Division arising out of the Lehman's case, to find leading counsel who is here present and now a High Court judge at the first hearing on one side of the court, arguing, I forget now whether it was for the subordinated or the non-subordinated or the non-subordinated creditors, it matters not. But then at the next hearing, he was on the other side of the court and explained that his clients had now taken a different position in the respective bonds. I just wonder whether it has any effect. So those are just some thoughts, rather random thoughts I had, which is simply really to encourage you to express what will certainly not be random thoughts. So thank you, and Jay, thank you.
No, thank you. Very good.
Very well, it's now open to anyone who wants to say something. Nobody ever wants to be the first, but when somebody has, then carries on from there.
Okay.
Yes,
I'll start the ball rolling. I have so many thoughts and questions, and I've had the pleasure of hearing this talk twice. So I won't ask, which gives me even more. But there's one thing that you said.
Because of Mexico, you understand.
Yes, one thing that you said at the beginning of the talk about control being the greatest priority. And I want to push on that a little bit, in the sense that there is absolutely no question that control creates the ability as a practical matter to affect distribution. But whether it's proper to think of it as a priority or the power to distort priority is a question. It's not, I certainly do not disagree with the underlying point, but does it matter if you think about it as a priority or a distortion?
Well, distortion, of course, contains an assumption, which is that the traditional liquidation priorities are somehow or other immutable, and anything different than that is a distortion. So I'm not with you right at the starting gate on that point. It seems to me priority sets as the way in which we are going to allocate value from a financially distressed company, period. And that's what we do, for example, when we say, well, you have a security interest in this property and therefore you can collect from its proceeds and all that. So if you think of that as simply a set of results that favor this group of creditors or this group of other stakeholders like the EPA or some other stakeholder over another group, then that is, seems to me, is properly called a priority. And I want to speak to all of my colleagues who grew up as I did, using the term priority as the central concept in insolvency or bankruptcy law. So that's my response to that. I mean, your question, of course, is a great one and goes right to the heart of it. But yeah, I want to claim that our not only do we need some new vocabulary, but we need to modify the way we think about some old concepts. In liquidation, they're still the same. That's fine. We can pursue in that way, but they're quite different, it seems to me, in continuation.
yes,
I want to say something more about control, because when you look in a U.S. Chapter 11 case, there's often a great deal of fighting on exclusivity and control of who can submit the plan. And that is because the one who has exclusive rights to submit a plan, which is real control, has great advantage.
Indeed.
Just give an example, even with priorities, take the federal renewal case, which in the United States is federal longer, large conglomerate, many tort claims, a mass tort case, huge amounts of bondholders, unsecured bondholders. Okay, both have equal priority. But under our laws of discrimination between classes, even if you had to give them equal value, you could pay them out through different mechanisms over time. And when you're dealing with many hundreds of millions of dollars of claims, the one who has control over these mechanisms, who kept exclusivity in the U.S., okay, and had a trustee in the UK, makes a big difference. Control is a big deal. I'm not sure that the U.S. Chapter 11 has a control problem, because one area where the judge really does get a lot of information is in situations when there's a motion to appoint a trustee and take the debtor out of possession. On that type of proceeding, there will be very large, when I say large, copious, detailed submissions to the judge as to why, even with our flexibility and debtor possession concepts, that debtor cannot stay in possessions, and there will be evidentiary hearings in court, and the judge will be heavily involved. So the judge is involved with control, and I have one more point, if you guys raise all this. Lord Richard raised, last thoughts. In the United States, the only mechanism that has been successful in dealing with next thoughts is Chapter 11. Notwithstanding Johnson and Johnson and
Yes.
counsel who are trying to push the limits in the Texas precepts and things. We've had many cases of church sex abuse, USA gymnastics cases, asbestos cases, breast implant cases, syndrome. We've had an immense amount, and the Chapter 11 system has worked very successfully. Class actions don't work in the U.S. because the Supreme Court of the United States in 2 cases in the late 90s held that the Chapter 11 system, that the class action system could not deal with future claims.
Right.
And that knocked out the class actions because a lot of these are continuing force of people develop the disease or the problem years after the exposure. So Chapter 11 is really our only way, and it has worked there.
Just one brief comment, and that is, I just want to be sure that our British audience realizes that, yes, what you say about the appointment of a trustee and how much would come out in one of those proceedings is quite right. But having said that, we also have such a powerful presumption against appointing a trustee that many cases where you might think it would be quite legitimate to put that sort of a proposal before the court will never be filed because it's so difficult to win them under the case law as it has developed.
Or even an examiner.
Or even an examiner, exactly. The judges have been very hostile to those ideas.
Anyone from the English part of the audience? Yes.
Just on the control point, I think it's very good points in relation to English schemes. The approach of the court here has traditionally been to compare, to view the scheme as whether this scheme is fair.
Yeah.
And only this scheme, and not to consider some alternative scheme.
Yes.
So whoever gets impressed with their scheme, practically has enough. It may not be the case on restructuring plans. There's a debate on that. In relation to schemes, that's the approach.
I think that's fascinating. I'd love to talk to you more about that because, yeah, I mean, that's for me a central kind of question that you ought to be addresses, you ought to be thinking about in how do we feel about schemes?
Yes.
Another one of these I'm very interested in the concept that we're talking about concerning creditors who are secured
Yes.
in the resolution world. And you said that secured creditors will only get the same as they would in liquidation.
Well, that's the proposal that this character over here and his co-authors have made. Yes, of course. What do I know? No, go ahead, please.
Oh, well, actually, I wouldn't say liquidation value. I've always said realizable value, which is to say what the secured creditor could have gotten in the absence of a continuation
Yeah.
of restructuring proceeding or orderly or going concern.
But that's a whole lot different from the assumption that underlies much Chapter 11 proceeding today, even theoretically and certainly practically, which is to say, I'm the secured creditor. I have blanket lien, as we call it, on all the assets, and therefore whatever I want is what you have to do because these are my assets. Well, time out. Not if you read the Uniform Commercial Code. They're not your assets. They're assets as to which you have certain rights, and those are basically liquidation rights, period. So, and as I say, Ronald Mann has written some terrific stuff about how commercial creditors say that those rights are really worth very little. And that's why very often banks who are fully secured nonetheless want the company to file for bankruptcy because much more value can be recognized in that context, usually going concern.
One clarifying point on that, it's important for the English audience to realize that there's a difference between the US concept of security, which is more directly property and asset based.
Yes.
And the UK
Quite right.
system, the floating charge. So the
Yes,
answer may
quite
come
right.
out differently depending on the underlying secured credit system.
Well, now we'll take away that thought. Thank you very much. And thank you very much to Claire for having fielded all these questions. There is some suggestion of there being drinks on offer.
And I do not want to be between you and them. But I do want to say one last thing.
You say not me the last word.
No. This very fine gentleman whom I first met in Israel many years ago.
Did we?
Oh, yeah. And well, I remembered it because you were a very important person. I was not. But yeah, and so I'm so grateful to you for having come. And of course, to Lord Richards for having made these comments. So finally, to all of you for having come and endured all this. Thank you very much.
Right. Thank you.
So now the drinks of which some has some mention in there. Again, I'm so grateful to both of you.
Not at all, Jay, it's great.
Oh, well.
Good, how are you? Great to see you, really good. Yes.